Okay, hello everyone. Welcome to the second meeting of the Judicial Review Committee to consider drafting regulatory preambles. Per usual, I'm going to start the meeting with two roll calls. The first one will be of committee members who are here. The second one will be of non-committee ACUS members that are attending. So we'll go ahead and get started. If you can just unmute yourself when I call your name and say here, just so we can make sure your microphone is working, that'd be great. We'll start with our chair, Curdy Dotla.
Here.
Thank you. Giancarlo Canaparo, don't see him yet. Betty Jo Christian. See you there. If you're having trouble unmuting, just let us know. But if you could just unmute Betty Jo and say that you're here, that'd be great. Okay, we'll come back to you. Don Elliott, I don't see him yet. Abby Gluck.
Hi, I'm here.
Hi, thank you so much. Kristen Hickman.
Here.
Great, thank you. Ron Levin will be joining at 2. Alan Morrison, I don't see him yet. Courtney Mallon.
Here.
Awesome, thank you. Mila Sahoni.
I'm here.
Awesome, thank you. Chad Squitieri.
Here.
Thank you. Dan Walters.
Here.
Excellent. Okay. Okay, so are there any members on the committee whose name I did not call? Okay, I'm going to move on to ACUS members who are not on the committee. Again, if you could just unmute yourself and say here. This group also includes our wonderful consultant, Dan Deacon. If you could just unmute and say here.
Oh, sorry, here.
Sorry, thanks. Chin Yu, I see you're here.
Yes.
Thank you. Amy Bunk.
Here.
Thank you. Bill Funk.
Here.
Thank you. Stephanie Davis.
Here.
Great, thank you. Okay, are there any other ACUS members either on the committee or not on the committee who are here whose name I did not call?
Betty Jo Christian.
Thank you, Betty Jo. All right, I think we got everyone, so I'm just going to turn it over to you, Curdy. Thank you.
Okay, sounds great. So I'm gonna run through the standard pre-meeting reminder of the processes and rules, and then we'll get started. So please note that only ACUS members, which includes government members, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and designated alternates have full speaking privileges. During the meeting, please keep your microphone on mute. And if you would like to be recognized to speak, please use the hand raise feature in Zoom. If you aren't familiar with how to use that, just feel free to ask a question in the chat or add a comment in the chat, which I'll try and keep an eye on if you'd like to speak. I will then call on you. You can unmute yourself to make your comments, and then please remute yourself when you are done. I will also ask that you're able to, if the ACUS members and alternates could use the keep your webcams on to facilitate the conversation. That would be great. With respect to other attendees beyond ACUS members and alternates, participation in the meeting will require the consent of the committee members. If there is time during the meeting, I will consider calling on such attendees during the discussion, and we will operate by presuming consent unless any committee member raises an objection. So if any such participant would like to speak, please do the same thing, indicate as much in the chat feature or by using the Zoom hand raise feature. Please wait to speak until I call on you, at which point you can unmute yourself to speak and then remute yourself when you're done. For all participants, please do not put substantive comments into the chat feature. Use it only to indicate that you would like to speak or to flag any technical issues. Other members of the Judicial Review Committee, including government members, or sorry, only members of the Judicial Review Committee, including government members and designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not participate in the voting unless you are a member of the committee. If you are unsure of whether you are a member of the committee, we have a list and you can ask that question in the chat. So with that, Kaja, can you pull up the document? We are going to start, just to fulfill some promises made during the last meeting, we're going to start with the comment on the title, for which I know Kristen would like to discuss. And then I believe Abby has to leave just after the hour, and has some comments. And so we'll go to Abby for those comments, absent objection, and then we'll proceed through the document top to bottom. So let's start with the proposed comment from Alan, which came in during the last meeting about revising the title of this recommendation. And if anyone would like to comment on it, please raise your hand. Yeah. Kristen, go ahead.
Thanks, Curdy, and thanks also for holding this particular question over to this meeting since I had to leave the last one early. I oppose this proposed amendment. I understand, Alan's reason for wanting to change the title was to tie it more closely to the language of the APA. But if you actually read the recommendation and the preamble to the recommendation, it's not just talking about the concise statement of basis and purpose as described in 553C. It's also talking about the preamble and the notice of proposed rulemaking. We use the word preamble a little bit interchangeably, I think, in talking about the portion of the notice of proposed rulemaking before you get to the regulatory text, and also the portion of a final regulation before you get to the regulatory text. So it's not actually accurate to call it regulatory requirements of statements of basis and purpose. So hence why I just keep the title the way that it is, lest it become too unwieldy by our saying regulatory requirements of notices of proposed rulemaking and statements of basis and purpose.
Okay, thanks, Kristen. Are there others who want to comment on the proposed change? If not, we will just move it to a vote. Okay, Bill, go ahead.
I wanted to second Kristen's position that I don't think Ellen's suggestion really fits to what this recommendation is all about. So I support Kristen's point.
Thanks, Bill. Alan?
No, I don't want to press on this issue, and I don't even think we need to have a vote on it. But we have regulatory preamble. The word preamble doesn't appear in any place in 553, and preambles. I mean, the preamble to this recommendation is a very different kind of a document than the preamble to the notice and proposed rulemaking and the final rule. And one reads this thing, regulatory preambles, and who cares the title. And so I'm not pressing for the because Kristen's clearly right that it applies more broadly than the 553C. But I would it may be regulatory explanations is a more accurate word. We use the words explanation in line 4 in the actual in the preamble here, and maybe somebody else can come up with a better answer than I have so far. And maybe we could also make it clear in the first paragraph that the word preamble doesn't appear anyplace in 553. And we could maybe say often referred to as preambles or something along that. I don't want to try to draft it while we're sitting here today, but maybe the drafters can come back and take a look at that and see if we can find some way to make it. I'm not this is not a substantive comment. It's just trying to find a way to make it clearer to people who are going to read this thing, what we're talking about and why we care about it. Thank you.
Okay, thanks, Alan. So I'm gonna take your comments as, if not withdrawing the amendment, at least. Okay, great. So we'll consider it withdrawn. As you note, the committee staff did make additional edits, to address the title suggestion in lines 3 through 4, where we tried to explain what we were referring to as a preamble, because I think the comment that it's not a term defined in statute was a fair one. So maybe folks could take a look at that sentence. And if they have additional edits to make that point even clearer, we can, if we have time at the end of the meeting, we'll, or we can come back to them when we come back to the document and do the start to finish procedure. But with that, I think, Abby, I wanted to open it up to you if you.
Yeah. Unfortunately, my medical call is starting right now, so I'm gonna come back in 15 minutes. I hope you'll give me a chance. And when I come back at that time, I really appreciate it.
Okay. Then, okay, let's continue to, I don't think folks have had enough time to think about this sentence. So, so we'll continue. Oh, John, did you want to speak to that?
Yes, I did. I didn't have a view one way or another about the title, but as a general comment, I think these documents have multiple functions. And I was troubled that we were really only focusing on the things that we're focusing on. And I think there's nothing wrong with the things that we're focusing on, but I do think the reason that the Committee on Judicial Review is doing this, I mean, regulatory preambles have multiple functions, and I think what we are rightly focusing on those are those that are necessary to facilitate efficient judicial review under some recent court decisions. And we may or may not want to cite those court decisions. There was a big argument about that the last time. But I do think we need at some point to frame this in terms of what we are and are not talking about. And perhaps in the preamble where we explain what preambles are, you know, we say, you know, from what angle we're coming at it. But I, for example, don't think that the statement of basis and purpose is sufficient to inform the public about regulatory requirements. And I talked about the ACUS recommendations in that area that a colleague and I had worked on and was endorsed by the Assembly. I think that's just a symptom of the fact that we have multiple functions here, and we're really focused on a relatively narrow set of them. And I think that's fine, and I think that's the right thing to be doing, and I'm not opposed to it. But I just think we need to signal, you know, what portion of the universe of functions we're purporting to address.
Thanks, Don. So this is another place for committee members who are attending that weren't at the last meeting where there were some similar comments discussed, and the committee staff bulked out the preamble to the recommendation here to make it clearer that preambles serve multiple purposes. So when we get down to that section of the revised preamble, maybe we can have a further discussion about that comment. Jeremy?
So this is obviously up to the committee to decide, but I would note that preamble is essentially a legal term of art at this point. OFR has published regulations for the past 50 years regulating how preambles are prepared for notice and final rules. I think it's cited later for another paragraph, but it might be useful to cite it here. Not only are they commonly known as preambles, that's actually how OFR terms them.
Thanks, Jeremy. Bill?
I wanted to respond to Don's point and just say, and ask Don if he doesn't think that the last paragraph of the preamble doesn't take care of his consideration. I mean, I wouldn't I had the same general concern that he had, that why aren't we telling him what this recommendation is all about? But the last paragraph begins by saying this recommendation is to show best practices that account for recent decisions of the Supreme Court. So I mean, I found that to be at least a place for, and perhaps could be bulked up, but I thought this did the trick that he was concerned about.
Just if I may respond briefly.
Yeah, go ahead, Don.
Yeah, I'm sorry I wasn't clear, Bill. I agree with everything you said. I really meant it implicitly as something, as a comment on maybe we need to frame it. We need to consider the framing in the title of it. So it's not just about everything in the world there is to know about regulatory preambles, but the narrowing language that you refer to rightly, I think in some way needs to become part of the title, and I leave it to the Committee on Style. But I think burying this in the preamble alone, while good, is a mistake, and that we need to sort of be consistent with what I take to be the practice of at least getting it, if not into the words of the title, which I think would be preferable, into the first sentence or so. So I defer to the Committee on Style on that, and I apologize for not having been clearer before, but that's what I had in mind.
Okay, thanks, Don. Dan Walters?
Yeah, I just wanted to plus one what Don just said about the importance of getting this into the title in some way. In particular, because that paragraph that Bill flagged is right at the end of a very long preamble to the recommendation, and it takes a long time to get there. It's a big wind up. It's talking about a lot of other things that are, extraneous to our focus here. And I think having something in the title could help, sandwich it a little bit and tee up the issues that we care about earlier, which would be a good thing.
Okay, thanks. I think it would be helpful for the committee to have an amendment to consider so that this discussion can be concrete. So if anybody has text they would like to propose revising the title to read, raise your hand and I will recognize you. Okay, John?
Why don't we just say best practices in drafting regulatory preambles? We got the idea of best practices in there. And then I would also say that we need a third sentence, in the first paragraph, but let's just focus on the title. But then we have the whole idea that comes from the preamble about under recent judicial decisions. We need to get that into the first paragraph, but that I would leave that to the Committee on Style. But my amendment is just to say best practices in drafting regular.
Okay, I think as with the title, it would be helpful to have a sentence that you would like the committee to consider, you or anyone else. So let's go to Bill next, and then folks can see if they have proposed language in the bracket that was just added to the document. Bill?
Well, I thought more like drafting regulatory preambles in light of judicial review was what I was thinking was be more responsive both to Dan Walters and what I thought Don was doing. So, I mean, it could be best practices in drafting regulatory preambles in light of judicial review, or just drafting regulatory preambles in light of judicial review.
How about?
Thanks. Sorry, John. I just want to make sure
that. I think that's a friendly amendment, and I'd be willing to just accept it. But maybe best practices in drafting regulatory preambles. Current best practices in drafting but I like the idea of having judicial review in there. So I apologize. I thought I was able to crystallize it in an amendment, but I haven't really done that. How about best practices in drafting regulatory preambles in light of recent judicial decisions? Because there may be, later best practices in light of other cases later. So recent judicial
Yeah.
decisions.
So I'm worried this is getting a little unwieldy, but before we do that, Alan, if the amendment to the title references judicial review, would that get rid of the need to add a sentence at the end of the first paragraph? Can we take that off the table if the title references judicial?
Sure. Yeah.
Okay, that's helpful.
And I don't think we need, and again, I apologize for doing this on the fly, but we don't really need drafting. That's obvious. So best practices in regulatory preambles under recent judicial decisions.
Okay, I want to, before we make further edits, give Kristen a chance to weigh in.
Notwithstanding my general preference for short titles, I have no problem with expanding this title, even making it a little unwieldy, because I sort of figure, well, it's an ACUS recommendation, and ACUS recommendations can bear slightly unwieldy titles. That said, I strongly dislike the inclusion of the word recent. Anytime you have the word recent in anything, I recognize that the recommendation will be dated, in the sense of having a date on it, and that, the reference to recent may be in reference, people will associate it with that date, but it's just so, I don't know. Anytime you use the word recent in describing something, I see this in law review articles too. It's instantly unclear as to exactly which cases, and I know the preamble goes on to explain and talk about some cases, but that temporal reference in the title, I find enormously problematic. I would go with just best practices in drafting regulatory preambles. I like drafting, actually, in drafting regulatory preambles in light of judicial review.
I'll take that as a friendly amendment and suggest that that should be the subject that we focus on. I think that would be just fine.
Okay, so I understand what is on the table to be drafting regulatory preambles in light of judicial review.
I think we kept the best practices in there.
I actually have one question for the ACUS staff, which is whether titles usually refer to best practices or not. I would sort of assume that's like baked into what ACUS does, but I don't actually know. So if the committee staff knows that off the top of their heads, that would be helpful to know.
There have been a few.
Okay.
Yeah, it's okay. There have been a few.
Okay, thanks. That's helpful. And then I also want to give Dan Deacon a chance to weigh in on whether that aligns with what his understanding of the underlying report is aimed at as well, if he wants. If not, no worries, Dan.
Yeah, so I think it's tough because I do sort of generally agree with what Kristen just said, but I was always thinking about this from the beginning as it was consistent, I think, with the original request for proposals, is about being topics that have changed recently. So for that reason, the report and the sort of ensuing recommendations don't address some things like, I don't know, the logical outgrowth doctrine or something like that, that I hadn't flagged as sort of like being subject to kind of like major recent changes at the Supreme Court level. So it does give, not having something like recent maybe gives like a little bit of a broader sense of what the recommendations are than at least sort of I had in my mind from the beginning.
Okay, thanks, Dan. That's helpful. Don, you were up next.
Yes, thank you. I'm sorry, but this is almost just a point of order, but my understanding is, having been a consultant on numerous recommendations and served on numerous committees, that the recommendations are the committee's product, and they don't necessarily have to jibe with what was in what was in the report that gave rise to the committee's recommendation. So I think it's up for the committee to decide what these recommendations really are. I don't think that I agree with the substance of Dan's point that they're not recommendations for everything. And that's what I think, that's what we were trying to solve with Bill and I with the word recent. And I agree that, how about current best practices in drafting regulatory preambles for judicial review? But using current rather than recent.
I just want to give the edits a chance to catch up before moving to you, Kristen. Just give it a second. Okay, great. Kristen?
I very much like substituting the word for instead of in light of. I think that makes it cleaner. Just my own 2 cents. I don't like current for the same reason I didn't like recent. If you really want to be precise about it, rather than using current or recent, say something like Supreme Court decisions from 2021 through 2026 or something like that. Be precise about it. Otherwise, obviously it's not going to cover everything. Later on in the preamble, as we've already noted, we make reference to all kinds of other ACUS recommendations, some of which are associated with litigation. And so we very clearly pull all of that in. Upon reflection, I also don't have any problem getting rid of the best practices, although I like best practices, but I really just don't like the reference to current or recent or anything like that. If you want to have a temporal reference, make it an actual specific temporal reference rather than the fuzzy current, recent, whatever.
Okay, thanks. So I think I'm gonna say we can replace in light of and for potentially without controversy. And then I want to go to Bill, and then I want to just vote on current, keeping current in or taking it out. And then maybe that'll be how we get off of the title. So Bill,
I just support Kristen's feeling about current. I don't like current either, but I certainly don't want to substitute a list of dates for Supreme Court decisions. They just best practices. Let it be that way.
Okay, thanks. Amy, go ahead.
Yeah, sorry to be a pain. As somebody who works at a federal agency, I'm a little concerned that using the term for judicial review will get people who are using this, who are looking at this recommendation to help them draft regulatory documents, that they're going to assume that they don't have to worry about other issues like NPRMs focusing on commenters, or I would hate to see the focus be solely on judicial review at the agency level. Thank you.
Sorry, Amy, before you go.
Yes.
Do I understand you to have been preferring in light of to for?
Yes, I would prefer that.
Okay, so we'll put that one back on the table and then we'll do a vote on that one after. Chad?
Yeah, so I would second the opinion to get rid of the current or recent language. And then also, I also actually don't like the inclusion of for, because it suggests that, that you're drafting a regulatory preamble like just for judicial review, rather than maybe to inform the public. A lot of the stuff that we have in this recommendation would be useful to members of the public and regulated entities in addition to courts. So I'd actually be in favor of not even using judicial review at all, but that seems like a minority view right now. So if we are going to have a reference to judicial review, I'd prefer to be in light of rather than for judicial review.
Okay, thanks, Chad. So we've gone troublingly close to 30 minutes on the title. So let's take a vote on whether to keep current in or to delete it. And the way I'd like to do this is we'll do the first, we'll have you raise your hand if you want to keep current in, then everybody will keep their, that'll be the vote. So if you raise your hand, you want to keep current in the document. Okay, so for voting members, please raise your hand if you would like to keep the word current in the title. Okay, last calls. Okay, so I had 2, which I think means the inclusion fails and we'll delete it. And so now we'll take a vote on the for versus in light of debate. So the way we will do this is please raise your hand if you prefer for. And if you don't raise your hand, that means you prefer in light of. Using the Zoom feature is easiest. So voting members, please raise your hand if you prefer the word for to be in the title. Okay, I have 4. I think I'm gonna need the committee staff to tell me if that is enough or not.
Kirti, you didn't vote, or you're for in light of, or are you in for? Because it's tied right now.
Oh, it's tied. All right. I have not raised my hand then if I need to vote.
Okay, so you're in favor of in light of?
Correct.
Okay, so in light of 5-4.
Okay. Okay. So we will keep going then. We have a 3rd committee meeting, so folks are welcome to submit comments ahead of that meeting and put the title back on the table. But let's keep going. Just gonna give that a second to update. Should we scroll down so that footnote 1 is visible? If that's possible. And then we'll just go and we can delete the bracketed text at the end of that paragraph. All right, so we're just gonna go paragraph by paragraph and ask if people either have objections to proposed edits or if they have comments on the paragraph. So the first paragraph, lines 1 through 4. Alan?
I'm sorry, I'm probably technically out of order, but may I suggest that we go to the recommendations? It would be a tragedy if this meeting were to end without getting through the recommendations. And preambles, we can argue about preambles forever. Anyway, I'm sorry to be out of order, but that's my thought.
Thanks. No, I understand the concern. I'm gonna keep an eye on the clock and see the pace at which we're going through the preamble. If you'll recall, the prior version was quite bare bones and the committee staff drafted quite a lot of text in response to comments. And so I do think it would be great if we can just give them some general feedback about whether that was going in the right direction. Maybe one thing the committee members can do is just focus on big picture reactions, similar to what we did last time, if there are major things that need to be in or out, and less on grammar and wording, which can come in written recommendations before the 3rd meeting. So let's go through the first paragraph again, if folks have comments on lines 1 through 4. And if not, we'll move to the 2nd paragraph. Okay, so the 2nd paragraph, lines 5 through 11. If you have comments, please raise your hand and I'll recognize you. We'll, I guess technically still part of that paragraph, go through, can we scroll down to capture the end of that paragraph? Thanks. So lines 12 through 15. Abby, are you back?
I am back. Thank you. Perfect timing.
Okay, and did you have general comments on the preamble or on the recommendation?
I have a comment that relates to 12 to 13. My other comments are more specifically related to different statutory provision, different phrases in both the preamble and in the actual recommendations, but I think this is probably a good time just to raise my objection initially, to provide context for the comments I'm going to make later. I think throughout this document, there is a less than ideal emphasis on the statutory text. And I think that is somewhat potentially outdated after Loper Bright. And so I think that throughout the document, there are an emphasis on purpose and justifications and all the different things you want to have in a preamble, but it really does need to have a justification grounded in why it's the best reading of the statute. And that is stated at least one time. And I don't think that in line 12, it's necessary to say why it's grounded in text, but I do see the words basis and purpose. I don't really know what basis means. I assume that is incorporating an emphasis on text. And I will say that, and I'll say that that's my operating assumption, which is why I won't object to that language. But when we get later and we start talking about the various considerations, there are things listed like purpose and structure, but not the actual words. So the statute, and I think with the current court and the current state of affairs, we really do need to incorporate some reference to words somewhere in here. So I don't have an objection, but I'm just going to say that I assume basis here means text. And if some people think it doesn't, then that's relevant to me to know.
Okay, thanks. I think it would be helpful as we go through the document if you want to identify specific language that you'd like to include to emphasize what I think was the intent, which was to capture the post-Loper, I guess, increasing relevance of statutory text. As to basis and purpose, I was wondering if to put an amendment on the table on the basis of that comment, we could put basis and purpose in quotation marks because it is coming from the statutory provision that is cited in the footnote. If that would make it, even if somebody might not know what that means, at least they will understand that we are quoting the statute and not doing anything else there, but providing very general background. So I'm gonna ask that that be on the table. Kristen, you have your hand up?
Yeah, I was just pulling up the text of 553C. If you really want to be accurate in tying it to the language of the APA, what you might do is say, put the quote starting before concise. A concise general statement, or, just the quotation mark starts with concise. And then it's concise general statement. And then, yeah, you could put either it's in brackets or the rules, basis and purpose in brackets. It's a little bit unclear exactly. I mean, it's not entirely unclear, but it's a touch unclear about which preceding noun the word it's is covering. But yeah, that way we make clear we're quoting 553C, and that includes the entire language of 553C that's relevant for this purpose.
Okay, thanks, Kristen. Chad?
Yeah, at the risk of backing up a couple lines, I'm wondering for that like 5 through 11, if we're actually being slightly inaccurate, given our discussion about preamble kind of being a loose term in general. It says like the APA requires these to be included in the preamble, but earlier we say like only some rules typically have a preamble. So I wonder if it's more accurate to say that the APA requires this sort of information to be alongside, or as 5 U.S.C. 553C says, incorporate in the rule. So it could be in the rule itself, not necessarily the preamble. And as written, it looks like we're taking a position like the preamble to an NPRM must include, or we might just say an NPRM must conclude to be precise, if that makes sense. So I guess the kind of technical issue is that this information could be pursuant to the APA incorporated within the rule itself rather than the preamble to the rule.
Yeah, so I see that staff suggested edit to a notice must include, I think, parallels the text of the statute and is agnostic as to whether it's in a preamble or the proposed regulatory text. If that edit is made, does that get rid of the need for the or incorporate in the rule language? If it's just getting rid of the reference to preamble, which I took to be the main thing you were taking issue with, Chad.
Yeah, I didn't track the exact what would happen if we delete preamble to be included in these kinds of regulatory period.
Sorry, so the second sentence at the end of line 6, if that sentence just reads,
Oh, yes. Yeah, I mean like a little slight problem with the sentence before, but I think that edit would be satisfactory to me.
okay. So
Yeah.
so I'm hearing you to say what's in the red line would work for you. Bill, did you have a comment on lines 5 through 6?
I was just going to say we're wordsmithing here, and I'm with Ellen that I'm afraid about timing and getting to the things that really matter, the recommendations. And I think the preamble follows the recommendations usually, and I'd like to second his idea of skipping now to the recommendations.
Yeah, so again, I hear you, and I'm going to continue to ask the committee to exercise restraint. But I did take the edit in 5 to 6 to be an accuracy edit that I think is helpful. So I'm going to treat the entirety of paragraph 2, lines 5 through 15. I'm going to take that as a whole and say we'll accept these edits unless there is an objection, and move on to the third paragraph. Okay, great. Paragraph 3, lines 16 through 20. This was in the prior draft and I don't think has changed. Okay. Seeing no hands raised, paragraph 4. Can we get the whole paragraph on the screen if that's possible? So line 21 on down through the start of the next page. Thank you. That's helpful. So 21 through 30. All right. Seeing no hands, we'll keep going.
Kirti, do you want to address Ron's
Oh,
sentence?
sorry. As before, I'm going to take the edit as being accepted unless there is a comment on it, and I didn't see any hands. So
Okay, great.
great. Okay. Paragraph, the next paragraph, lines 31 through 36. Abby.
This is one of those places where I flag the language for not mentioning text. So can you scroll up a little bit? On my page, it starts on 29. Is that where it's starting on yours? Yeah. Okay, it's a little different. Okay. So so here on yours it's on because of the red line, it's now on line 31. So when courts review the rules, they assess the reasonableness of the rule in light of the comments, the regulatory alternatives, and the justifications. I would say that statutes are in there, but they're a second afterthought. Statutes, courts may assess the agency's interpretation of relevant statutes, and that is going to be the primary assessment now. And so it seems really important to either put it in the top part when you're mentioning the things that are really important. The second sentence in that paragraph is like seems to be the sentence you're saying, this is the thing to focus on, everybody. And I wouldn't put that, I wouldn't just cut and paste it like that, but I would add, when courts review rules, they must often assess the agency's interpretation of the relevant statutes, just that part. I just think that really has to be front and center. You can just take that first phrase, the first before the comma, before footnote 15. And ideally, you would put it in the second sentence of the paragraph, which is where you seem to be providing the most emphasis. I don't know if the books are going to disagree with that, but that would be my recommendation from a legislation perspective.
Okay, thank you, Abby. I take the rest of that comment to be the first description of what happens during judicial review should refer to reviewing the agency's statutory interpretation. So achieving that by flipping the order, there might be some stylistic edits that we need to make, but I don't think we need to discuss those conforming amendments. So do folks have reactions to, does anybody object to putting the emphasis on the agency's interpretation by making the move as indicated in the red line? Kristen?
So I don't want to be too persnickety, but on the other hand, the agency's exercise of delegated discretionary authority and the reasonableness of the rule are more or less effectively the same thing. I mean, Loper-Bright requires an assessment by a court about whether not only the agency's interpretation of the statute, but whether the agency possesses delegated discretionary authority. So
Yeah, can we achieve this just by, sorry, can we undo the current red line and just switch the order of the sentences?
well, but one thing that you might do is consistency with longstanding agency practice then does go along with reasonableness. So maybe, you make the first sentence be, they must often assess the agency's interpretation of relevant statutes and the agency's exercise of delegated discretionary authority. Then say courts may, or something like that. I hate to put it all in one sentence, but in a sense, put it all in one sentence.
I don't object to that, and I think that the exercise of delegated authority is in part also actually a question of statutory interpretation. That's what I think you're getting at, Kristen, in your comment.
Mm-hmm.
Okay, let's give the edits a chance to catch up.
I don't think it's an or. I don't think it's an or. It's and or, right? Kristen, you don't think it's an or, right?
I'm iffy on whether it's an and or an or. It's really this is or if the or is an and, because sometimes it's the agency's interpretation of a statute.
Right.
Sometimes
Right.
the agency has delegated discretionary authority,
Right.
but not always.
Okay.
I guess at the end of the day, I don't care or and. Bill may have ideas.
Okay.
Yeah.
Let's
Okay.
leave it at and.
My
and
idea
Bill,
is to leave it to the staff to.
Bill, I'm recognizing you. Please go ahead.
I said, I think we should leave it to staff to do the, we'll have another chance to see it. So let's let the staff do the ands or ors and whatever else here.
All right, thank you. So as before, the question was whether anybody objects to flipping the emphasis of this paragraph. I didn't see any raised hands before, and I don't see any now. So I think we can continue on to the next paragraph. The next paragraph is new in this version of the draft. It's a response to comments from committee members asking for more context about the cases on which the recommendations are based. Is there a way? Yeah, sorry. Thank you for getting the full paragraph on the page. Again, please raise your hand if you have big picture comments about this paragraph, not wordsmithing comments. Okay, then we'll keep going. Lines 51 through 57. Again, we will take the proposed edits as accepted unless unless there are comments from the committee members. Abby?
I know this is not actually wordsmithing, although it might seem this way to people who don't live and breathe this. there is an ongoing question about whether this doctrine only applies, when the statute is ambiguous. And I think the language here concedes a little too much ground. And the edit helps, but I would say, I think I can work with you afterward to try to come up with a phrase or something to wordsmith this, but I do think it's important. Or you could say, in determining the matter falls under the major questions doctrine, courts look at the ambiguity of the statutory text, past agency precedents. But I think you want some ambiguity language in there because there's a particularly big fight brewing at the court now about whether ambiguity is required to trigger this canon or not. If you just look at the learning resources opinions for evidence of that. So, I mean,
Yeah, I think, Abby, can you continue to think about what your proposed language would be? And in the meantime, we'll go to Kristen.
So I have proposed language which may help.
Thank you.
Instead of under recent formulations of that doctrine, make it under some formulations of that doctrine. And instead of on line 56, make it some courts look at past agency practices and regulatory antecedents. That allows for a lot of latitude. Because I take Abby's point. This doctrine's a mess at the moment. It's getting a little bit clearer, but not a lot, and there's a lot of variability among the circuit courts in how they're applying it.
Thanks, Kristen. All right, are there any comments based on the paragraph as amended? Okay, then we will, as I mentioned, consider those edits accepted. Move to the next paragraph. Again, this is another paragraph that was added after the last meeting. So lines 59 through 65, we'll consider Alan's edit taken. Are there any comments on this paragraph? Okay, let's keep going. Line 66 through 69. Any comments? Great, let's keep going. If it's possible to get that whole paragraph. This is just the summary of the prior ACUS recommendations paragraph. Are there any comments on line 70 through 80? No? All right, let's keep going. All right, final paragraph of the preamble, lines 81 through 90. We will consider the edits taken unless there are folks with comments. Okay, then we can move on to the recommendations. Okay. Can we get all of recommendation 1? And then I'd like to just go sentence by sentence. So lines 91 through 96. Would anyone like to speak? Okay, then I'm Kristen, go ahead.
Sorry, can somebody explain the point of the as applied to this rule? I'm not sure I follow what that's trying to capture.
This is Alan's edit, I believe. Alan, do you want to explain?
Yes.
Go ahead.
The question often is not what the statute means in the abstract, but it means as it applies to this particular rule. And I wanted to be sure that the agency doesn't just talk about what the statute means broadly, but what it means in the context of the rule that is being considered. And it's just a little gentle reminder in that.
I guess what I find confusing is the reference to the as applied to this rule. I don't think of statutes as applying to rules so much as rules interpret statutes. Maybe I'm the only one who has this.
Maybe it should be to identify. Yes, I mean, I don't disagree with that. I may have gotten it backwards, how the rule applies to the statute rather than the statute applies to the rule.
Bill, you have your hand up. I want to recognize you next.
Yeah, Ellen, what about moving as applied to after my thing where it says explains why the agency believes the proposed or final rule reflects the best interpretation of the statute as applied to this rule.
That'll work.
Yep. I'm good with that, I think.
Thank you.
Great. Alan, is your hand? Okay, perfect. So last call for comments on lines 91 through 96. Okay. Let's go to 97 through 98, little a. Abby?
This is a problem about 97 to 98, but also 106 to 109. The text is not here in these 5, A through E. And so we could put it in E, how the agency's interpretation of the statute coheres with the statutory text, comma, structure, right? But, and I can live with that, but A is basically a different form of the same inquiry. There's two different kinds of inquiries here. It's whether the agency has discretion, like reasonableness, and whether the agency is interpreting a term in the statute in a way that is the best determination of the statute. It is a little strange that the mention of text is the 5th mention and not the 1st mention. I can live with it, but I really want to point it out for the group. If the point of this, I wonder if people would object to moving E up at least to B or C, like the interpretation of the statutes at E, when C is about factual and empirical questions, it just seems out of order. I'd rather see E moved up if I understand that if the group is focusing on Loper-Bright reference to the word reasonableness or whether there's room in the statute to delegate discretionary authority. But that's not going to be the only set of circumstances in which the agencies are going to be issuing rules.
Okay, thanks. I just want to provide one bit of context in case there were folks that weren't at the first meeting, but the revisions to recommendation 1 were meant to make it clear that as the first sentence of recommendation 1 indicates, agencies should be clear about how they're interpreting the relevant statutory text and what they are relying on to support their action. And then A through E are all ways they are explaining their statutory interpretation. So with that context, Abby, I take your proposal to be moving subsection E to subsection A to be first.
I would do that, or at a minimum, I would move the first part of subsection, the first clause of subsection E involving, add the word text as you have and bring it up to the top.
Yeah, I think it's probably cleanest to try and move the whole thing up. So let's, for the committee staff, so let's put that proposal on the table. And then Bill, you have your hand up.
And I was going to suggest exactly the same thing. I think this is the first thing you think about. The rest are all sort of, maybe these will be applicable, maybe they won't, but those are, the first one is always going to be an issue. So I support moving it to 1.
Okay. So let's consider that new lines 97 through 100. Does anybody have further comment or objection? Okay, let's go to lines 101 through 102, new subsection B. Lines 103 through 104, new subsection C. All right, 105 through 106. And last 107 through 109. Okay, then
Real quick. You need
Go
to
ahead,
add
Kristen.
an and after, oh no, sorry. Apologies, I see it now.
Okay, so let's move on to recommendation 2 then. Are there folks who want to speak on recommendation 2?
So,
Sorry,
yeah,
Kajik, could you tell me the bracketed amendment, does that come from one of the committee members?
Yes. Yeah, it was either to remove the word expressly or to say expressly or implicitly.
Okay, and sorry, who was it? So I can give them a chance
that was
to.
me.
Yeah.
Okay, great. And Ron, do you want to just explain that? And then I'll go to you after that,
Well,
Bill.
it's not clear whether it's already been done and I have to defend it or whether I need to propose it. It sounds from what I just heard as though I need to propose it.
I think maybe if you can pick the thing that you
Doesn't
want.
matter. I'll make the same point either way. Which
Great,
is we should
let's
not
go.
use the word expressly as a limiting qualifier here, because we should treat express delegations and implicit delegations the same, or rather the agency that perceives either should identify it um, and so forth. So I thought the limitation that was in the prior text was not right and therefore should be changed.
Okay, and can I ask a clarifying question, Ron, which is whether would your concern be equally addressed by just deleting? I want to make sure I understand. Was the proposal, you could also accomplish this by just deleting the word expressly? So
Yeah.
just, okay,
I
great.
said I was open to both, either.
Okay, that's helpful. Thanks. All right, Bill, you were up next.
Yeah, I'm a little concerned that, I mean, I agree with Ron that the local right does not necessarily require an express delegation, and implicit delegation may still be possible. But I think that if we're talking about what should be in the preamble, if it's going to be an implicit, if they're going to claim an implicit delegation, somewhere we need to say they have to explain why they think the language, the statutory language, implicitly does that. If it's express, if in other words, if this recommendation just limited itself to expressly, that would be good enough because you wouldn't need to explain anymore. But if it's implicit, then I think we need something that says to explain why they think it is implicitly. And that would take, I think, a second sentence.
And I'm going to ask you the same clarifying question I asked Ron, Bill, which is if the sentence just referred to statutory provisions that direct or authorize the agency, would you not have any concerns?
Well, I'd still have a concern because, I mean, to the extent we're trying to talk about what should an agency do, right? And if we're going to leave the possibility that they're going to use an implicit delegation, then the best practice would be to explain why they think that this statute that doesn't expressly delegate it, in fact, implicitly delegates it. I think that's a necessary addition if we don't limit the recommendation on to say expressly.
Okay, thanks. Kristen?
So I think we ought to take out. I agree with Bill that we may need another sentence suggesting that agencies articulate in greater detail why they think a particular statutory provision supports their rule. I think we ought to get rid of the reference to expressly or implicitly, because I think there's a real argument that implicit delegations are no longer a thing. And I would be reluctant to have this recommendation seem as though it is endorsing the possibility of implied or implicit delegations.
Okay, thanks. So I think what is on the table is, we're gonna take a quick vote, and it's gonna be if you'd like to delete the word expressly, you will raise your hand. So the sentence would read, any statutory provisions that direct or authorize. And if you would like to keep the word expressly in, you should keep your hand lowered. In the meantime, Kristen, if you want to think about language for your proposed additional sentence, or bill, then we can talk about that after we take the vote. So please raise your hand if you would.
Could I respond to Kristen?
Sure, go ahead.
I just don't think there's any basis for saying that implicit delegations have all been eliminated by Loper Bright. We've had them for decades. The sentence that refers to express delegations does say, for example. I don't see how you can possibly read that as getting rid of implicit delegations that have been a part of our legal system for a long time. So
I think
would
that's the
reject-
whole point of Loper Bright. That's why
Sorry,
I read
I
an
don't
article
wanna-
about it. That's
don't
why
wanna-
I think we ought to take it out, because of the fact that there is a disagreement over it. And so consequently, I don't think we should be endorsing in this recommendation the idea that there is such a thing.
But the agency may believe there is.
Well, fine. Then the agency can articulate that, and I'll work on language for a second sentence. But I think if we include the word implicitly here, then we are suggesting that we are taking a position about the continued validity of the idea of implicit delegations. And I don't
Right.
think that that's something that we should just imply without more.
So the question on the table is whether this sentence should read any statutory provisions that direct or authorize the agency to. So the decision is whether to delete the word expressly that was in the original draft, and the word implicitly would not be in the sentence. So let's take a vote on whether to delete the word expressly as indicated by the red line. If you would like to delete the word expressly, please raise your hand using the Zoom feature. Okay, great, that passes. So we
What are you
have,
asking the noes?
I think it's mathematically impossible for the noes to win, but if you would like to.
Yeah, I'd like to know how many noes there are.
Okay, if you would prefer to keep the word expressly in, please raise your hand. Make sure if you voted already that you lower your hand from before, please. Okay, there was a discussion of referencing the idea of implicit delegations in a new sentence, but there's no text on the table to discuss. So I am going to, Abby, do you have proposed language prepared?
I would like to, I want to oppose the idea of adding language. I think, Ron, I think that.
Sorry, Abby, I think until we have language on the table to discuss it, it's sort of, we're
Okay.
just gonna, yeah. So let's, if people have proposed language to put on the table, please raise your hand. Remember, we have a third meeting, so you're welcome to propose that ahead of the meeting, and then we can discuss it at the third meeting.
I think we should discuss it at the third meeting.
Yep. That's an option. Okay, so are there other comments on paragraph 2? Abby?
The comment that I wanted to make is that I do think the language as it now reads includes implicit delegations. Ron, I would just say that I would read it that way. Because it's the authorization language, someone would read it to say that, if the structure or words in the statutory text would otherwise author those delegations, I would just say that you might sleep easy, because I read it that way.
You're muted, Curie.
Thanks, Dan. I appreciate it. Let's table further discussion of implicit delegations until we have proposed text to discuss, and move to paragraph 3. And if there are folks who would like to comment on paragraph 3, please raise your hand and I will recognize you. Okay. Seeing no hands, we will move on to recommendation 4. Let's leave the swap suggestion until afterwards. Abby?
Same comment as I've been making throughout, the text is not mentioned in this list of things that the agency should be mentioning when they're discussing the major questions rules. So A should be the text of the statute or some language to that effect that we can develop.
All right, are we able to put that in? Okay. Are there other comments on recommendation 4? Kaja, are you able to expand the comment? Thank you. Ron, did you want to speak to your proposed?
Yeah.
Was there?
I thought it was sort of self-explanatory. These,
If you, do you have suggested text too? That would be helpful.
no, I did not have suggested text. And it would depend on whether the sense of the committee is favorable to my point, and if so, we might have to let that go to the next meeting, but maybe they're not favorable as they were not favorable to my previous point, however compelling its reasoning was. Here, the point simply is that if somebody invokes the major questions doctrine and the agency wants to say, we don't think it applies, they should say that. As opposed, what it says now is the agency should address the merits of that without raising any question about whether it's well taken.
Okay, thanks, Ron. Abby, did you have a response on that point?
You're asking me? I think Ron's point is synergistic with what I said. I think you can.
Oh, sorry, your hand might have still been up.
Oh, no, go ahead.
Okay, then Kristen, did you have a comment on Ron's point?
I think Ron's point is a valid one, and so I've at least partially drafted some language that we could debate if we want to add potential language. But I agree with Ron. Maybe other people disagree and think we don't need to add anything. You can tell me how you want to proceed.
Yeah, I think it'd be helpful if you would suggest the language that you have in mind.
Sure. So create an E. Any explanation for why the agency does not believe its rule raises a major questions issue. I'm not super wedded to this text, so anybody who thinks that they can improve upon it is welcome to do so.
I would say
Okay.
maybe problem
Thanks,
rather than
Kristen.
issue.
Sorry, Ron.
Excuse me.
Dan is up next.
Yeah, I think Kristen's language is fine, and I like it. An alternative that occurred to me would be to amend the first sentence of recommendation 4 to say when a genuine major questions doctrine issue arises in the course of developing, and then just omit subsection E that Kristen added. So I think those could be alternatives to each other and basically accomplish the same thing. I think one slight advantage of my edit would be that I don't really even know what an agency would say in the explanation for why the agency doesn't believe that there's a genuine major questions issue. If they don't think that there's a genuine issue and it's very obvious and it's being frivolously invoked by commenters and the like, I think it's enough to just sort of let that not have an explanation. I don't think that's necessarily required by best practices. So I think the change at the beginning is a little bit, it leaves a little bit more to the discretion of agencies to figure out how to navigate this potential problem.
Okay, thanks, Dan. So for the purposes of the discussion, let's consider those two independent suggestions. So we can take one, take the other, take both, not do any of those things. So Ron, you're up next.
Thank you. I basically like Kristen's version. I would change the word issue to problem because the agency's point in this scenario is that there isn't a problem here. Issue is so open-ended that it doesn't squarely frame that of the intent of E. I would not take Dan's approach because genuine has lots of connotations that are not spelled out. Anyone who's studied the law on summary judgment, a genuine issue of material fact, sees that it can be used different ways in different contexts. And I think rather than use a term that is that ambiguous, we should go with E, which I think is straightforward.
Okay, thank you, Ron. Bill?
Well, I think I agree with Ron generally. I mean, it appears to me that major question issue only comes up when the agency's never going to say, oh, our rule raises a major questions issue. They're always going to say, no, it doesn't. All right. So we're always using this number 4 to respond to somebody who doesn't like the rule, either before we've issued it or after we've issued it, to say that we don't think that this raises a major questions issue, problem, whatever. So I think I agree. Genuine sort of doesn't add much, but I generally agree with Ron on this.
Okay. Thanks, Bill. I guess I'll just note there's one recent example of an agency invoking the major questions doctrine to rescind a major rule, the endangerment finding. So I'm not sure that's 100% true, but I take the point about when it's most relevant. Kristen, did you have?
Yeah, I'm happy to go with problem instead of issue. I take the point for why problem is a better, maybe a better language. I don't like genuine for the reasons already stated. Genuine is very much in the eye of the beholder. To the extent that people think that there might need to be something to that effect so that agencies don't feel obligated to discuss the major questions doctrine in every rule, perhaps at the end of E, you could put a comma and say, if necessary, or as needed, or something like that.
Okay. Abby, do you have
Kristen, can I make a friendly amendment to your text? So
Sure.
if necessary or as needed, any other explanation, right, for why, because the things above it are explanations for why the major questions doctrine doesn't apply. The scope, all of those things, or any other, it's still, I would say any other. And then I personally would say major questions concern. I think problem is just not.
Well, but those other items talk about the elements of the major questions doctrine, whereas this is for why the agency does not believe its rule. It requires the agency to state outright what its belief is.
True, but the scope of the rule and the regulatory antecedents are directly relevant to whether it's even a major question in the first place.
Sure, not denying that. I just think that this is different.
So I don't feel strongly about that. I would say major questions concern, major questions problems, kind of a strange word. But it's up, I'm not gonna stand on that, but I do think that not B, A, B, C, I mean, there's other things that are missing. Political importance of the rule, particularly the major questions inquiry, but text and scope and antecedent are three of the major reasons why you might say this is not a major question, but
I like concern better than problem.
okay, I'll take that as a 50% win, my dear.
I'm gonna exercise a prerogative to propose, can we do this in bracketed text for E? Any other explanation for why the agency does not believe its rule? And then the bracketed text would be implicates a major question. The reason for that proposed edit is because it might be true, but I think it implies that if major questions is on the table, the agency's action is doomed or under threat or less likely to succeed to call it a concern or a problem. And I don't know that we want to make that implication. Okay,
Then
Alan,
you shouldn't have major questions concern.
there's a Kristen, if you want to directly on that respond, that's fine, but I just want to be sure.
Yeah, I was just, this is just a direct response to that. I have no problem with bracketing that, and I take your point. But then I don't think it should be major questions concern because you don't implicate a major questions concern. You would implicate the major questions doctrine.
Yeah, so my suggestion was implicate a major question, full stop. Because I think
Fine. I'm good with,
some,
I don't have a problem with that if people prefer it.
all right, and then we would delete the rest of that sentence, or at least that's the proposal there. Alan, you were up next.
Yes, I support that as it, and especially when we deleted the as needed because we don't need the as needed because this is a such as. Is it in order to make a suggestion on the first sentence in 4 now, or would you have me hold it?
If you're okay holding it, I want to get out all the
Fine,
comments.
yes, I'll just keep my head up there. Thank you.
Okay, thanks, Alan. So Bill, you're up next.
We have a problem with the introduction here. It says a full range of factors that a court may consider. And an explanation is not a factor. The other 4 things are factors.
But I'd like to just make sure we get out all the comments on subsection E before moving to other parts of 4. Ron, did you have comments on subsection
Yes.
E?
This is about E. I mean, it's about E, but okay.
So on the question you're asking, Curtly, I would go back to the version based on Kristen's proposal. I think implicates is a little fuzzier because it seems to say raises a substantial question, which may not be correct, but just is something worth talking about, which I think is not the intent here. I think more straightforwardly, the agency would say, I don't think it raises a major question problem, but if it does, then, or concern, if you want, but if you think so, then here's what we say about it. And just to say whether there could be some question about it is not what the agency wants to say. They want to say no, I think. Often they will want to say no.
Okay, thanks, Ron. So what I want to try and get to as quickly as possible is just 2 alternates that we can vote on for subsection E. Kristen, did you have more on that? Sorry, Kristen, you're muted.
I think Alan was ahead of me unless he just didn't lower his hand.
I think his hand is still up because of a
comment
he wants to make on the other portions of 4.
So I'm happy to vote between raises a major question concern as needed versus implicates a major question. I think I'm going to
Can we just pause right there to let the committee
sure.
stop type that in? Okay. And if you need Kristen to repeat it, please just ask.
No,
Yeah,
it's already in there. So it's raises or implicates and then raise. I mean, I can type out the whole thing. Would that be easier?
Can we, yeah, can
Well,
we
I
just
mean,
have
you know,
two-
except for the fact that you've got some deleted and things like that. So I see Kirby's point. So how about raises a major question concern, comma, as needed. That's one bracketed item. The other bracketed item is implicates a major question. Now let me say why I think I like the first language better. And the reason is that if we just say implicates a major question, based on how this is phrased, we are telling an agency that every time they have a preamble, they ought to talk about why the agency does not believe that its rule implicates a major question. So every rule needs to have a major question discussion. Now, maybe that's just smart in this day and age, but I think I would feel more comfortable saying, you know, if the agency doesn't believe if the agency feels like it needs to address it, so that's the as needed part, then the agency should explain why it doesn't believe its rule raises a major question concern. I think that captures the original point that Ron was making better than just implicates a major question. But anyway, that's my take.
Okay, thanks, Kristen. I am assuming Alan and Ron's hands are still up from before. If that's not right, okay, Alan, go ahead then.
I do think that I understand Kristen's point, but I think that the last sentence in the first part of in the text part of Rule 4 says they should address the thing if they think that the court may consider in resolving a major question. That is, I think we cabin in the concern that Kristen has that everyone will think they have to do it in every rule. That this is only if you meet the situation in 4 in the basic part of 4. Which says the agency thinks that somebody may think it's a major question that doesn't have to do it in every case. So I would go with the shorter implicates a major question.
All right, thanks, Alan. Abby, did you have comments on the choice between these two options?
Yeah, I wanted to offer a friendly amendment to Christians, but I'm confused about do we vote on the word genuine in the first sentence?
We haven't taken a vote on genuine yet.
Okay.
I'm happy to do that first, but I don't want to chop up the conversation we're having.
Well,
So
the reason I'm asking,
yeah,
is that the E depends on the first sentence in 4, as Alan just said. So I don't think we should have the word genuine there personally, and I think that it affects my views on how we vote on E if it's in there, so I think it's relevant. I think for E, I think it's a weird language thing. The major question concerns just awkward phrasing. I would just say, as the agency doesn't believe its rule raises a concern under the major questions doctrine. That's just better loyally. I think the issue about major questions concern, I understand. I would just, if we were going to go with E the way Kristen prefers it, I would say doesn't believe its rule raises a concern under the major questions doctrine, because
sorry, Abby, I just want to, before the committee staff makes those edits, I just want to try and take some votes to get some things off the table. So Abby, if we end up keeping Kristen's language, I want to come back to you and have you propose further edits, if that's okay. I just don't want to.
I want to explain why I was adding that, because all rules, an agency might think their rule is a major question, but doesn't raise a concern with the major question. It's major, but doesn't raise a concern on the major questions doctrine. And what we're talking about here is a doctrine, which is why I would, or rule, but that's the reason that I would just change the language that way. But we can come back to that if you want to have a separate discussion on Kristen's proposed language.
Yeah, I think that's my preference, to try and keep things clear. Bill, do you have any?
Yes, I don't understand why Kristen feels it necessary to limit the number of cases in which the agency is going to have to make this explanation when the introductory language to 4 says that you only go to A, B, C, D, and E if there is a major questions doctrine that arises in the course of the rule or invoked by a comment. So it's clearly not in every case that they have to do this. It's only when there's an issue. When there's an issue, then they ought to make an explanation and they ought to take account of these factors. So I mean, I support implicates a major question. I actually like implicates an issue under the major questions doctrine better, but I don't, anyway, I don't understand Kristen's concern in light of the introductory language to 4, and that maybe she could explain it.
Okay, I think what I want to do, given the time, is let's take a vote on genuine, and then let's take a break because we're at an hour and a half. And then we'll finish the debate on subsection E. So the way we'll do the vote on genuine is, I'm sorry, Abby, do you have a comment on the genuine language?
I have a question about whether it's in order to ask if we have something different we would put instead of genuine. Do you want us to raise that separately, or do you want us to raise it as part of this vote?
Let's do it separately. So Chad, did you have comments on the genuine?
Related to Abby's comment, I've heard some pushback on the word genuine, but I would want to say that I want some word in there, even if it's not genuine, because
that's where I was going.
Yeah, so I think we're on the same page there, because when we say invoked by a comment, like anybody's cousin can just like issue a comment saying this is a major questions doctrine. So I think we need some sort of limiting function.
A comment of cogent materiality.
Dan, sorry, Dan, you have your hand up?
Yeah, so since I was the one who introduced the genuine word there, I actually might want to do a friendly amendment to my own a proposed amendment and say that we could move genuine over to right before invoked and put it in parentheses. So you could say when a major questions issue arises in the course of developing a rule, or can you move that there, sir? Rule or is invoked by you could put parentheses around or is invoked by a comment and add the word genuinely right before. Yeah, everything's moving around, sorry. But you would just basically associate the genuine term with the comment received, just to indicate that you don't have to respond to every comment that might raise the major questions doctrine. I think that would capture more of the meaning or the problem that was raised earlier that I was trying to respond to with my proposed amendment.
Okay, I think that is that's a pretty substantive change, actually, and so I think even though it's going to seem a little formalistic, can we just go back to, thank you. And let's just quickly take a vote on how things stood. We'll take our break. If there are additional comments, we'll take our break. We'll go through subsection E. If there are, in the meantime, additional suggestions for alternatives to genuine, if it doesn't end up staying in, we will take those after that. So let's take a vote on genuine as it, can we delete the second? Yeah. The second reference to genuine, thank you. So let's take a vote on just the first part of the first sentence of recommendation 4. If you would like to keep the word genuine in, please raise your hand. If you would like to delete it, keep your hand lowered. All right, so we have 2 votes to keep it in, which, unless the committee staff tells me I'm wrong, means that we are going with the deleting it for the purposes of the rest of the discussion. As I mentioned, let's take our 10-minute break. When we return, we'll finish out the discussion on subsection E. And if people have additional language they would like to add to sentence 4 or other textual amendments, please have them ready when we get back and we'll discuss them then. Okay, from some of the talk during the break, it sounds like there might be an amendment that will be proposed that would interact with the discussion about subsection E. Did that group designate somebody to propose text? And if so, do they want to raise their hand? Okay, Bill?
While not a member of the committee, I can't technically propose it, but I was one who started the conversation during the break. And the suggestion is to essentially move E up into 4 as being that's what you do whenever the issue arises. So we talked about language, and I've just sent to Katya proposed language for 4 that which would follow, would say, when a major questions issue arises in the course of developing a rule or is invoked by a comment received in response to a notice of proposed rulemaking, and the agency wishes to address it, the agency should explain in the preamble to the proposed or final rule why the agency believes its rule does not raise a major questions concern, addressing as necessary the full range of factors that a reviewing court may consider in resolving a major questions challenge, such as, and then you'd have A through D. So I can say that again, or Katya maybe can see the language that I sent her.
Okay, yeah, I was gonna Kaja, I guess I defer on whether you think this is easiest to address by having 2 separate recommendation 4s, given the extent of the edits, or whether doing it this way you think would be fine. Just for your purposes of keeping track of
Oh,
the edits.
I'm fine with this. I got it.
Okay,
Katya,
then,
one comma should be put in the first line there, in the course of developing a rule, comma.
Okay.
and then we would be deleting subsection E if
Yes.
the inserted text is
Correct. Correct.
accepted. So Alan, I see you have your hand up, but I'm actually gonna just put Kristen on this spot to ask if she has reactions, given that she proposed the language that is.
Yeah, I'm actually fine with this.
Great.
So
Then
I have,
Alan?
yes. I don't understand why we have the agency wishes to address it language in there. I mean, if the agency wants to address it, it does. If it doesn't want to address it, it doesn't. Why do we have the language in there? That's number one. Number two, I would like to change the first part of this language here. Instead of when the major question arises, if a major question may arise in the course. And that is to say, we're telling the agency to look out for this. And if it does that, it should do the following.
Okay, so I'm going to consider that a separate, distinct suggestion, and we'll vote on those separately. And I'll just clarify my understanding of the reference to if the agency wishes to address it, is that it's trying to address the idea that some major questions arguments are frivolous and some are substantial, and the agency need not respond to frivolous invocations of the major questions doctrine. But perhaps people have suggestions about how to make that clearer. Abby, sorry, Alan, is your hand still up, or is this?
Yeah, I just respond to that. I mean, why would the agency think that the ACUS is telling him you have to respond to a frivolous major question point? It just seems to me that this phrase, "and the agency wishes to address it," is superfluous and should be eliminated.
Okay, so I think in light of Alan's comment, why don't we just for the purposes of the discussion bracket, yeah, perfect, thank you. And then Abby, you were up next.
Yeah, I have two proposed amendments to this language. I think it's not about wishing, and the agency believes the issue requires addressing, is what I would say. And the agency concludes, or whatever the agency believes agency concludes the issue requires addressing, is what I would say, because that gets at the problem. And I also would suggest that the very end of the sentence, instead of such as, it should say including but not limited to.
I consider that a friendly amendment.
Thanks, Ron.
Including but not limited to is an
And delete the word
alternative
such
to
as.
yeah.
Yeah, delete the
okay.
word such as.
All right, Alan, is your hand still up?
I'm
from
sorry,
before?
no.
Okay. All right, so let's, and Alan, sorry, does the bracketed does that fully capture the proposal you had if a major questions issue arises?
That's fine with me. If and when it's fine. I didn't like Alan's formulation of saying, agency, look out for major questions. This is saying, this is just about the preamble. If it comes up, all right, the agency will know it if it comes up. They don't have to look for it. I don't.
Okay, so I'm gonna, to try and move us through this, let's take a vote on whether the sentence should begin with when or if, because that is still on the table.
I took it off the table by saying I accepted the if. And it was my when, so I accept the if. I thought
Okay,
that was
and maybe the
that
way
was
we'll do this is I will ask if there are any objections to if, or anybody who wants to comment on that, and if not, we'll consider it accepted. Okay, great. So now let's take a vote on the first bracketed choice. So you will have an option later to accept or reject this full set of edits, but as to the edited text, if you prefer and the agency wishes to address it, I'll ask you to raise your hand. And if you prefer the agency believes the issue requires addressing, you can keep your hand lowered.
Again, I thought that was a friendly amendment and I would accept it, having had originally said agency wishes to address it. I'm happy to accept the friendly amendment. The agency believes the issue requires addressing.
Yeah, because why don't we just quickly take a vote? Yeah. Okay, so if you would
Question about that.
prefer,
I have a question about
go
that.
ahead, Ron.
Yeah, I just wonder if requires connotes a legal requirement that is not intended here.
Point
And if
taken,
it-
where the issue should, whatever,
So I would say believes it should address,
what did you say?
believes it should address.
Yeah, okay, sure.
Better.
Okay, because it sounds like there is some gravitational pull of the second version, I think what I'm gonna do is say, unless I hear an objection, we will proceed with the agency believes it should address. Kristen?
This isn't an objection precisely, but it needs to be the agency believes it should address the issue.
Yeah,
Okay, so
Otherwise, I have no
any-
problem with that.
Unless anyone objects to using the formulation, the agency believes it should address the issue, we will go with that and delete, and the agency wishes to address it. So we can just clean that up a little bit. Okay, can we just, while folks are reading the as revised text, just quickly fix the and at the end of subsection D. It would need to revert to having it at the end of subsection C. Okay, so let's.
Could I suggest that the staff break up that sentence? It's in the further edits, not now. It's a hugely long sentence there.
Okay, let's table that till we get agreement on the substance, if that's okay, Alan. So, let's do it this way. Are there any objections to the text as amended? If so, please raise your hand. Okay, great. Can we accept the text then? Great. And then we will take Alan's suggestion to break up the sentence. If there is a purely stylistic edit that we can make in the next draft, we will ask the committee staff to make that. And I'll just give them a second to note that in a comment. Okay, perfect. So then we can, are there any other comments unrelated to what we've been discussing on recommendation 4? If not, we'll move to recommendation 5. Okay, great. Then once the committee staff is ready, we'll scroll down to recommendation 5. Okay. Bill, it looks like you had a comment here. Did you want to discuss it further beyond the comment? No, okay.
I think the first issue is whether this should be moved up above 4. I mean, this was, I think, Ron Levin made the same point as I had made in comments that it seemed like this should follow 3 rather than come in after 4. In other words, the 3 talks about how it's consistent. Now we're talking about we're not consistent, all right? So it seems like this 5 should naturally follow 3.
Okay. Does anybody have an objection to flipping the order of 4 and 5? Okay. So then on the substance of what will now be recommendation 4, Bill,
Then
did you have
yeah,
anything beyond?
Yeah, my question was, should we say something about addressing reliance issues?
And did you have any text that would implement that?
Yeah. For example, why the agency's prior interpretation did not create significant reliance expectations.
I might ask Dan, not to put you on the spot, but if anything comes to mind that would capture the need to address relevant reliant interests. Dan Deacon, sorry. Lots of Dans.
Yeah. I don't know about language. I mean, I would say generally here, this was meant to be in a situation where the agency is changing its interpretation outside of a situation where it's exercising delegated discretionary authority. And there is just a lot of unclarity and I think contest right now over the role of reliance interests in those situations as opposed to in the kind of like Fox television stations. So I don't know, like as a matter of kind of my research, et cetera, like whether an agency has to talk about, or I suppose it always can if it wants to talk about, but whether that comes up in judicial review in these situations, I think is just unclear right now. And it's probably going to be subject to, judicial decisions in the next few years with the Trump administration changing a lot of interpretations.
Okay, just so we have something on the table, and would referring to is there any way to so I guess one way to do it would be explain the departure by discussing, for example, and then if we could just put this in brackets as an option to put on the table, any relevant reliance interests and it, I guess, potentially could be read as agnostic as to whether reliance interests are ever relevant. So that's just putting something on the table so we can discuss. Bill, does that adhere with what you were hoping?
That would be really good. I would be happy with that.
Okay, so then go ahead. I'm sorry. Okay, so
under Ron.
Are you
okay,
yielding to me?
great. Yeah, go ahead, Ron. Thank you.
Yeah, I wouldn't do this. I would leave it out entirely. The thrust of 5 is for the agency to explain the motivation for changing. Bill wants to bring in a possible reason someone could raise why you shouldn't change. I think you can't cover everything. I think what it now addresses covers a certain purpose. And I think Bill is bringing in a different subject, which is certainly germane to the administrative decision, but you really, you can't cover all the reasons why the agency maybe shouldn't be doing what it's doing. I think what it says now covers the original purpose of 5, and that's former 4, now 5, and that's good enough.
Okay, thanks. Could I just ask the committee staff to scroll down to the last recommendation, just so everybody has in their head that we also discussed the reliance issue in the context of the more arbitrary capricious context. So just to underscore Dan's point, that recommendation, I guess now 4 is a pure change in statutory interpretation, or is meant to capture a pure change in statutory interpretation. So I just wanted folks to have that context in their mind. So let's scroll back up, and are there further comments on what I take to be, I take the debate to be whether we generally want to even reference reliance interests in the context of a change in position on a statutory interpretation issue. So are there further comments on that front? And if not, we can just take a quick vote. Okay, so then let's take a quick vote. If you want to include the bracketed language, I'll ask you to raise your hand. If you do not want to include the bracketed language, you should keep your hand lowered. All right, everybody in favor, voting members in favor of including the bracketed language, please raise your hand. Okay, I don't want to call you out, Bill, but is this this was stemming from your comment, right? I haven't misunderstood.
Yeah, but I can't vote because I'm not a member of the
Oh,
committee.
that's right. I'm so sorry. No, you're right, of course. Okay, all right. So we have 2 votes in favor. If you guys can lower your hands, all those in favor of removing this bracketed language, so not having the bracketed language, just so we have all the votes. Okay, so we have 2 in favor of including it and 3 in favor of deleting it, so the deletions win the day. Okay, Bill, did you have more?
Yeah, and I'm not unhappy about the last vote. And now another question is, should we say why the prior interpretation was not the best interpretation of the statute? In other words, Abby wants us, and I think correctly, wants us to focus on statutory text. And here we're talking about all sorts of policy reasons why the interpretation was not a good interpretation. But it seems to me the first one should be why the agency's prior interpretation was not the best interpretation of the statute.
Yeah, is this another place where we would just move what is now in the last subsection to the top, and that would accomplish the purpose rather than adding in
Okay,
Maybe
yeah, that's fine. Yeah.
Okay.
Yeah, I think that's fine. I just think it should be the first one rather than the last one.
Thank you. I saw it, but I decided to hold my fire on this one because I have one more coming.
Okay.
Ron?
I don't know why line 141 doesn't cover this. Maybe line 141 should say it should explain why the revised interpretation represents the best. That, I think, necessarily encompasses why the alternatives, like the ones that previously prevailed, is not the best. And according to Loper Bright, we want the best.
Okay, thanks. Ron, can I summarize your comment as saying it's repetitive, but not inaccurate?
Which
That as written,
are you
I
talking
took you to
about?
be
A
saying,
or D or E or both?
I think that's what I'm asking. I just want to make sure that I was understanding your comment correctly.
Oh, I see. It's the same one.
Yeah.
Yeah, it's somewhat repetitive, but I'm not sure it's
Okay.
horrible.
Okay, so the only suggestion is to change current to revised. Are there any further comments on this recommendation with the latest revision proposed by Ron?
Yeah, I'm not really opposed to A.
Okay. Okay, then hearing no objections, we're going to consider these edits accepted. And then move to recommendation 6. Are there any comments on recommendation 6? Do I see you wanting to raise your hand, Abby? Yeah, go ahead. You're on mute, sorry. Abby, you're still on mute.
Sorry, thank
Yeah.
you. I have this, sorry, I'm holding my hand up. I have same comment here, because text is not being mentioned at all in the factors that are being considered in 6, A through E. So I would just add, you see, you have B, statutory objectives, but you don't have text, and text should be before. So there should either be a new subtitle, a new sub before B, so B becomes C, and, how the rule advances the best reading of the statutory text or comports with the best interpretation of the text.
Can I ask Dan Deacon if he has a view on that, given the, I think, distinction that we're trying to make here between arbitrary and capricious recommendations?
Yeah, or have
Yeah,
the rule comport to the text. I don't mean advance is best reference, but I think it's just a strange thing to have purposes, objectives, and not text. So if you don't want to have any of that, you shouldn't have just objectives if you're gonna start talking about interpretive tools.
Sorry, Dan Deacon, if you don't have anything to say, that's okay, but.
Yeah, I mean, I think I agree sort of with the substance of Abby's suggestion. I do think having the best interpretation of the text language does tend to confuse kind of where we are we're kind of in the arbitrary and capricious thing here. So if we said like how the rule comports with the, I don't know, statutes, textual criteria or something along those lines.
I would have criteria. I would just say something about how the rule comports with the statutory text. Just keep it simple. I would do, yeah.
Are there other comments on Abby's proposed addition? Okay, and are there other comments on recommendation 6 generally? Okay, then let's consider those suggested edits taken and go to recommendation 7. All right, Ron, you had a couple of edits that I think are self-explanatory, but if there's anything else you wanted to say about them, I'm happy to give you the floor.
A lot of things I think are self-explanatory do not commend themselves to other people. So I would just say I don't I'd like someone to explain why adequately is needed. And as to the others, I guess the argument is self-explanatory that if you say potential without significant potential, it is too broad, so I would qualify it.
Okay, so rather than ask somebody to defend adequately, I think what we'll do is we'll start with the text with Ron's amendments and ask if there are people with comments or objections to the recommendation as it reads now. Alan? Oh, sorry, Alan, you need to unmute yourself.
I don't think we need the word adequately. I mean, isn't that implied in everything we say? Number one, and then where are we on the significant comment requires the significant potential? Are we using significant twice in the same sentence? I'm not sure where we are on that.
Yes, unless you would like us not to.
I don't think we need the second significant there. Significant one has the potential to change the agency's approach. That's pretty significant.
So I see.
So I would delete the second significant and delete adequately.
Okay, so I
Which
think
obviously
that,
can be taken up separately.
yeah, I think deleting adequately is sort of the baseline we're operating from at the moment. So that's in there. And then you've raised a question about whether the second significant that Ron had suggested adding is what it's adding. So I see, Bill, your hand up, but I just want to go back to Ron to give him a chance to explain.
You're going to me?
Yeah,
Sorry.
just on the significant potential, if
Oh.
you wanted to say anything more about that.
Well, I think anything has a potential, but the alternative that I suggested is I don't know if we need the sentence at all, because what follows it elaborates on what we mean. And so that sentence, I'm not sure actually contributes anything.
Okay, thanks, Ron. Bill, you're up next.
Well, I agreed with Alan that I don't think you want define significant comment as significant potential. I don't think Ron's concern about anything having potential is a real one in terms of how this would be interpreted. But I also think Ron's point that the whole sentence is in a sense unnecessary. So I would say take out significant or take out the whole sentence.
Okay, thanks. Dan Deacon, can I just ask if that sentence is trying to, or is capturing something in the case law that we would lose if we delete it?
It's kind of trying to capture the materiality sort of standard from the case law. I actually think this was added after the first meeting, I think in response to a suggestion from Don Elliott. I'm not sure if he's still here. I can only see a few people on my screen. But I think this wasn't something that was in my initial, like the proposed recommendations in the report.
Okay. Thanks, Dan. Would it work to, so I'm going to put a proposed edit on the table. If you could add a bracket in the sentence that reads significant comments to which the agency respond. If you could add after well-reasoned comments, a bracket or start the open bracket there. That have the potential to change an agency's response or approach to the role. And then end the bracket after that. Probably need some cleanup edits, but just trying to incorporate the idea that of materiality that Dan mentioned back into the.
I'm okay with that. I'm okay with that amendment.
And then, Ron, does that do anything to assuage your concern that everything has the potential to change an agency's mind?
It doesn't really assuage my concern because I think it is not directed at what we should understand as the concept of materiality is whether it is one that it would be unreasonable to ignore. And just looking at it in the abstract as something that could be used to change it does not really capture the idea that the agency really darn well better heed that comment, as opposed to one that it it could, if believed, change the response, but it's a very poor suggestion. But again, I'm not sure that it's adding meaning, and so deleting the entire sentence seems like another possibility.
Okay, then if there aren't folks who think we should be doing more to capture or explain or allude to the fact that we're referencing materiality, I'm happy to proceed from the bracketed suggestion, which would leave the suggestion on the table is just deleting the second sentence. Are there further comments on the recommendation 7 as revised? And if not, I will assume that once the bracketed language is deleted, that everyone is fine with the amendment as revised.
All the bracketed language?
Sorry, just the one that I suggested. So just at the end of the introductory sentence. Yeah.
What would remain?
I think it's about to show up on the screen. So it would look like this.
That confuses me. It looks like the 161 to 63 has been deleted. Is that right?
Correct.
Okay, that's what I wanted.
Correct. Okay, so let's, hearing no objections or Alan, go ahead.
Sorry, the sentence doesn't end there. It says significant comments to which the agency should respond include well-reasoned comments that argue that the agency, and there's nothing.
Colon.
Oh, I'm sorry. Okay. I'm sorry. My fault. All right.
Okay,
Okay.
great. So then let's go to
I apologize.
recommendation.
Okay.
No worries. Let's go to recommendation 8.
What about 169 to 70?
Oh, I'm sorry. I think maybe I was unclear. I was assuming people are okay with the entire recommendation as redlined. If not, are there comments on the proposed edit in subsection E? Bill?
Yeah, I don't really understand what it's saying. I mean, it's comments to the agency that argue that the agency can improve the rule or analysis supporting the rule by incorporating constructive suggestions. Whose suggestions? The comments?
Yeah.
Well,
yeah, go ahead.
by,
do you want to
well,
explain?
so can improve the rule or analysis supporting the rule by incorporating suggestions. Suggestions from the comments. I wouldn't even say constructed, by incorporating suggestions included in the comments. All right, that would make it clear to me. Can improve the rule, supporting the rule by incorporating suggestions included in the comments.
That's fine with me.
Could I ask a clarifying question, Ron? Could you give a couple of examples of what you have in mind here? Is it supporting studies? What is it you think?
Well, so I think A through D is all responding to comments that there's something intrinsically wrong with the rule as proposed. And what I wanted to capture is and these are sort of defensive positions. What I wanted to capture is the idea that even though it would be okay, I, the commenter, have an idea to make it better. And here's something you could do to make it better. It's not that you would criticize it on grounds A through D, but still, I think you could do better here. And that's what the intent is to put forward. So
Okay.
A through D assumes something's intrinsically bad. And my hypothetical commenter says, yeah, it's okay, but it can be better.
Okay, thanks. That was helpful for me. Are there further comments on the new subsection E as revised? Bill?
Oops, I thought we had already adopted that. I was going to go to D. I think there's a problem with D.
Okay, if no one else, I'm just gonna give 5 seconds to see if anybody else wants to discuss E, and if not, we're gonna take it as accepted as amended, and then Bill, go ahead on D.
Well, I just want to note that it requires a grammatical change as stated in my memo, because you'd move the agency on the prior line into A, B, C, and D so that the grammar works.
Okay, let's have the committee on style look at that if that's just
fine.
just a grammatical edit. Okay, great.
That's
So
And
Bill-
I recede from my question on D. It's fine.
okay, so then Ron, is your hand up again, or is it still
Down.
up from?
It's down.
Okay, great. So then I think we have a version of recommendation 7 that is agreed to as shown on the screen, and we can go to recommendation 8. Are there any comments on recommendation 8? Okay, seeing none, let's move to recommendation 9. So Bill, I see your comment. Dan
Mine is
Deacon,
the
did you-
same as Ron Levin's. That we both are. It's essentially the same.
I think Bill's point is cogent.
All right. Dan, did you want to generally explain what this recommendation was trying to capture, just to respond to the generalized confusion, and then we'll do the specific.
Sure. So this
like-
is meant to capture basically State Farm and Regents. The idea that when you're rescinding a multi-component program, you might have to think about or explain why you're rescinding all the components as opposed to only some of the components. I agree with the sort of overall suggestion. I think that this makes more sense read in light of my report, because this 9 reflects a little bit of my own spin on State Farm and Regents. But I can see standing alone, and I understand people won't be reading my report along with the recommendations necessarily. So I agree that standing alone, it could probably be improved just to be more like, I mean, this is essentially just like, think about State Farm and Regents, the airbags part about State Farm.
In light of that explanation, Bill, are there any edits that would make it clearer? Or are you kind of not interested in the recommendation at all?
I frankly think we could do without 9. It's pretty technical and unusual, and I just, in light of these recent Supreme Court cases that we're talking about, I think it would be difficult to try to make this thing clear, and I certainly don't have language to do it.
Okay, so before we delete it in the red line, let's just all keep in our minds that that's one option. But if there are other suggestions to make this clearer, I'd like to get those out. Chad, you're up next.
Yeah, I would also be in favor of deleting 9, and that it seems as written to kind of impose a kind of standalone justification that you have to explain why you're not deleting independent parts of the rule. And I can get that there might be situations where you want to explain why you didn't take that path, but not all the time. Similarly, so like when you're creating a rule, there might be reasons to explain why you didn't create only, half of it or a third of it, but not all the time. So I'd be in favor of getting rid of 9 because it suggests an independent requirement that I'm not sure I agree with.
All right, I don't see any other. Dan, go ahead. Or Dan Deacon.
Yeah, I mean, like Don Elliott said earlier, you all can do whatever you want, but I would just point out that the reason it's in here, State Farm and Regents are the only 2 Supreme Court cases that we really have on the obligation to consider alternatives, and they are both of this form as opposed to the other forms of the obligation to consider alternatives, which is why I always, just by way of explanation, why I always had it as, as part of the draft recommendations as they appeared in the draft report.
Bill.
Well, I suppose I proposed eliminating it because I didn't have any language that would make it better, and I thought it was sort of technical. But we're coming close to the end of our time, and it would seem to me that if Dan or Dan together with the staff would like to try to take a hand at rewriting 9 for the next meeting, I certainly would be willing to sort of postpone consideration of deleting it until we saw a redraft of it that was less confusing and more specific.
Okay, thanks, Bill. I'm happy to do that if we can just note that this debate arose during this meeting, so the committee staff knows to take another look at it with Dan. And then we can move to the last recommendation. Recommendation 10. Are there any comments on recommendation 10? Okay. Then we are through the document. We have half an hour that we can give folks back. I will note that our next meeting is Wednesday, April 22nd from 1 to 4 Eastern time. And then I'll ask the committee staff if there's anything else we should discuss before we let people go. Oh, I guess I should also say thank you to you all for participating in this meeting, and of course everyone who came to the prior meeting. Ron, I see you have your hand up. Is there something?
Yeah, I got here an hour late, but did the committee also go over the preamble to the preamble's recommendation?
Yes, we
Okay.
have gone
I
over
missed
the
it.
preamble. Maybe what we could do, because we have this third meeting, is if there's anything based
Right.
on the edits that you've
fine.
made that you want to comment on, we'll do them at the top of the next meeting, if that's okay.
Yes.
Okay, great. Kaja?
I don't have anything other than I'll circulate the committee's proposed recommendation from today, and we'll see you all next week.
Thank you, everyone.
Thanks. Bye.